you to our annual Jurist in Residence lecture, hosted by our Law and Government Institute. The Institute helps students explore how government works and the roles that lawyers play in making and implementing the law. As a result, our students develop a passion for government law, which in turn leads to Widener Law Commonwealth alumni working in all areas of government law and public service. Our alumni are key to ensuring that the rule of law is rightly developed and faithfully implemented. I hope you find today's lecture engaging and thought-provoking. It is now my pleasure to introduce to you Adrienne McClendon, who will be a 2022 graduate of the law school. Adrienne is one of our 2 Patrick J. Murphy Law and Government Fellows. In that role, she researches government law issues, represents the Institute to the student body, interacts with policymakers, alumni, and other members of the law school community, and helps plan Institute events like this lecture. She also currently serves as the Vice President of the Law and Government Student Society. Please join me in welcoming Adrienne. Adrienne, the microphone is yours.
Thank you, Dean Hussey. Good afternoon, everyone. The Jurist in Residence program welcomes a judge to the Widener Law Commonwealth community. Each jurist serves a 2-year term and is hosted by the law school's Law and Government Institute. While at Widener Law Commonwealth, jurists in residence give lectures and teach special classes to law students. The Honorable Royce L. Morris is the judge of the Dauphin County Court of Common Pleas. After more than 25 years of distinguished service as an attorney and civic service to his community, Royce Morris was elected to serve as judge in the Dauphin County Court of Common Pleas in 2018. Throughout his legal career, Judge Morris represented individuals and corporations in criminal matters and municipalities as solicitor and general counsel, often litigating complex and politically sensitive matters on behalf of those clients in state and federal courts. Judge Morris has provided numerous continuing legal education seminars for the Pennsylvania Bar Institute and the Pennsylvania Association of Criminal Defense Lawyers, having previously served that organization as president, vice president, and treasurer. He also serves as the jurist in residence for Widener University Commonwealth Law School. Judge Morris received a gubernatorial appointment to serve on the Pennsylvania Commission on Sentencing and served on the Pennsylvania Bar Association's task force on the Code of Judicial Conduct. Judge Morris served on the House of Delegates for the Pennsylvania Bar Association and is the former chair of the Equal Professional Opportunity Committee for the Dauphin County Bar Association and the Capital Area Managing Partners Diversity Initiative. Named by Philadelphia Magazine as a Pennsylvania super lawyer from 2008 to 2017, he rated at the highest level of professional excellence, AV preeminent, by his peers at Martindale-Hubbell. He is a graduate of Temple University with a Bachelor of Arts in Political Science. He received his Juris Doctor degree from the University of Maryland. He also completed an intensive program at the National Criminal Defense College at Mercer Law School in Macon, Georgia. Since joining the bench, Judge Morris has been assigned to supervise family and juvenile court. He also receives assignments in orphans court and handles criminal trials. Please join me in welcoming Judge Morris.
Thank you very much, Adrienne, and thanks to Dean Hussey, and thanks to Rob Teplitz, who is and responsible for the Law and Government program now. It's truly an honor for me to be the jurist in residence at Widener Commonwealth Law School. And this lecture series is a very important part of that. And we're privileged today to have someone who participated in, I think, what's going to move juvenile justice forward in Pennsylvania. As we know, in light of the recent scandals that our juvenile justice system has taken in Glen Mills and Wordsworth and Devereaux, and all the places where abuse was identified, the governor put together an interbranch task force, and Rick Steele was integral as a part of that. And we have the pleasure of having him with us today. Richard Steele is the executive director of the Juvenile Court Judges Commission, and I've been blessed and fortunate enough to have been appointed about 2 weeks ago to the Juvenile Court Judges Commission by Governor Wolf. Mr. Steele began his career in 1979 as a juvenile probation officer in Northumberland County, PA, and eventually became chief juvenile probation officer in that jurisdiction. In 2005, he was hired by the Juvenile Court Judges Commission and subsequently promoted to the positions of juvenile court consultant, aftercare specialist, director of policy and program development, deputy director, and then eventually executive director. Mr. Steele is responsible for directing all operations of the Juvenile Court Judges Commission, including the agency's legislative program, statewide grant program, developments of juvenile court standards, juvenile court consulting services to advise judges, legislators, chief probation officers, and others on matters pertaining to juvenile court law. Beginning in 2010, Mr. Steele served as a member of the leadership team responsible for the coordination, development, and implementation of the Pennsylvania Juvenile Justice System Enhancement Strategy, better known as JJSES. And from 2014 to 2016, Mr. Steele served as the statewide coordinator of these activities. Mr. Steele is a member of the Pennsylvania Commission on Crime and Delinquency, its Juvenile Justice Delinquency Prevention Rules Committee, the Administrative Office of Pennsylvania Courts. He is also appointed as a member of the PA Child Welfare Council, the Council of Reform, and the Inner Branch, which is the most important for our consideration today, the Inner Branch Juvenile Justice Task Force. He was a member of that. They completed their work in June of 2021. He holds a bachelor's degree in psychology from Gettysburg College and a master's degree in business administration from Shippensburg University. And he was integral to that task force, but he also has information on where we go from here now that we've looked at and examined juvenile justice on the statewide level. So I turn it over to Richard Steele.
Thank you, Judge Morris. And I'm going to take a second. We're going to be sharing a screen here. Hopefully, that's the plan anyway. Can you see the screen?
Yes, we can see your screen.
Very good. All right, very good. If you could go to the next slide, please. All right, so again, thanks, Judge Morris. Good afternoon, everyone. Thank you for your introduction, as well as an overview, a little bit of what we're going to be talking about today. As mentioned, I'm Rick Steele. I'm the Executive Director of the Juvenile Court Judges Commission, and it is certainly a pleasure to be here with all of you today as we examine some of the critically important findings and observations of the Juvenile Justice Task Force. Today's session is entitled the Pennsylvania Juvenile Justice Task Force, Findings, Recommendations, and Next Steps. From the task force's inception in late 2019, there have been ongoing efforts to keep the field abreast of the various topical discussions, applied research, and data analysis and interpretation inherent to the proceedings. Then at the end of the task force work in the spring of 2021, an assortment of system recommendations, 35 in all, were made with the singular intent of juvenile justice system reform. The format of our session today is to review with you some of the key components highlighted by the task force. These include the areas of diversion, alternatives to fines, financial obligations in general, risk assessment, alternatives to placement through the use of graduated responses, racial and ethnic disparities, and record expungement. You will be provided with an overview of selected issues for each topic, followed by a review of updated data trends related to that particular topic. The task force, when we did our work, utilized 2018 data. For the purpose of today's presentation, we've taken the opportunity to replicate that analysis using fresh 2019 statewide data. We will then end our session with an overview of what we refer to as next steps, followed by the completion and submission of the Juvenile Justice Task Force recommendations. An electronic copy of the task force recommendations, I believe, has been provided to all participants today. If not, I certainly can make arrangements for you all to get a copy of that. Special attention today will focus on an overview of the various pending legislative proposals coming out of the task force recommendations. Before we go further, I think it's important that we provide some background about the Juvenile Justice Task Force. In December of 2019, the Interbranch Task Force on Juvenile Justice was created through the efforts of Governor Wolf, along with leadership of both the Senate and the House, as well as the Supreme Court. The group was tasked with conducting a bipartisan, comprehensive, data-driven assessment of Pennsylvania's juvenile justice system and making recommendations for reform supported by research. Individuals associated with the Pew Charitable Trusts served as staff to the task force, along with a few individuals from the Crime Justice Institute. I was appointed as a member of the group. Other appointees that may be familiar to you included Judge Kim Berkeley Clark of Allegheny County, who also serves as chair of the Juvenile Court Judges Commission. Also, Judge Douglas Reichley of Lehigh County, Jim Anderson, Mike Pennington, who is the executive director of the Pennsylvania Commission on Crime and Delinquency, and Russ Carlino, who's the chief juvenile probation officer in Allegheny County. The remaining appointees were made up of members of the legislature, the governor's office, the Department of Human Services, the Office of Mental Health and Substance Abuse Services, a prosecutor, a defense attorney, and various system stakeholder representatives. The group was co-chaired by Senator Lisa Baker, Senator Jay Costa, and Representative Tara Toohill and Mike Zabel. The task force first met in February of 2020 with this very diverse membership, inclusive of various system stakeholders appointed by the entities responsible for its creation. The original plan was for the group to present its recommendations by November of 2020. With the start of the pandemic, the project timeline was altered to include final recommendations that were ultimately made in the spring of 2021. Meetings occurred consistently from May 2020 through the end of 2020 that primarily focused on the review of data obtained mostly from the Juvenile Court Judges Commission database. Other data was provided by the Administrative Office of the Pennsylvania Courts, the Department of Human Services, and the Pennsylvania Department of Education. This data, in turn, was analyzed by staff associated with Pew. At the conclusion of the intensive data evaluation and review, the task force membership, numbering over 30 individuals, was assigned to one of 3 working subgroups and directed to use the data to generate recommendations for system reform. These 3 groups included the general topic areas of pre-adjudication and diversion processes, oversight and accountability, and finally, disposition. Beginning in January of 2021, the subgroups met individually and rather intensively. In February, the full task force was provided with a list of recommendations established by each subgroup and combined into a single document. Many issues related to the details of certain recommendations remained unresolved with each subgroup. Considerable attempts to gain consensus within the entire task force proved to be challenging, as many of the recommendations were rather extreme in their scope. On June 22nd, the final report and recommendations of the Juvenile Justice Task Force were released at a media event held at the Capitol. The report contains background information and data that was deemed most significant by the Pew staff responsible for writing the document. As I mentioned earlier, there are 35 separate recommendations contained in the report, many of which have multiple detailed sub-recommendations. These sub-recommendations, I should mention, are the source of much of the controversy that still exists as to the feasibility of the various recommendations. Each of the 35 recommendations were voted on by the members of the task force as to support or not support. As such, each recommendation is individually identified as to the level of support, that being unanimous, consensus, which was a vote of over 2/3 of the members, or majority, which was 51% or higher of the members voting to approve. Although the task force work was very intense and at times grueling, in many ways the work is just now starting. The recommendations include many that would require statutory amendments, some regarding rules of juvenile court procedure, and others that would impact standards, regulations, and/or policy, and certainly practices. While much debate occurred about how the task force deliberations may have been flawed in any of a number of ways, the fact remains that some very solid recommendations, ones that might undoubtedly improve our system, are contained in the report. Later on today, we will take a quick look at how these changes may be playing out over the next few months. More important to today's program, it's critically important that we pay attention to what our own data tells us about how youth are processed here in Pennsylvania's juvenile justice system. It is this data that provided much of the ammunition for the critics of our system. Some of the data is surely alarming, such as a general lack of pre-petition diversion, such as the use of informal adjustments, high rates of adjudications for first-time referrals, high rates of placement on first referrals, placements where the most serious substantiated charge is a misdemeanor, high placement rates for technical violations of probation, youth aged 10 to 12 who are petitioned on their first referrals, examples of justice by jurisdiction, where similar cases are apparently handled much differently in different jurisdictions, and significant issues of racial and ethnic disparity at each system decision point, and which increases as the system penetration deepens. For today's discussion, we've decided to look at 7 areas that relate to the deliberations of the findings of the task force. For each of these general topic areas, we will provide a brief overview of the issue and how it is impacted by statute, rule, best practice, and research. We'll then take a look at the updated state aggregate data from 2019 to get a sense of where we are as a system in regard to the topic. One of the broader findings from the task force is that similarly situated youth are experiencing vastly different outcomes based on where they live in the state. In each session today, we are going to take a closer look at this variance. And so unless there's any further questions or comments, let's move on to our first area of focus. A considerable amount of time was focused on the concept of diversion. We know that research shows that most youth are not on a path to future adult crime, and that unnecessary involvement and processing by the juvenile justice system can increase the likelihood of recidivism. We also know that there are considerable negative collateral consequences of a delinquency adjudication that have been well documented. On the other hand, various forms of diversion, when applied under the right circumstances, have proven to be highly successful in reducing future additional juvenile justice involvement. Diversion is of particular relevance for young, low risk, and/or first-time offenders with less serious offenses. Pennsylvania's Juvenile Act and the rules of juvenile court procedure endorse the fundamental principles of pre-adjudication diversion through the utilization of the least restrictive alternative when imposing appropriate responses to juvenile crime by providing for various alternatives to formal dispositions and even alternatives to the filing of petitions. An additional form of diversion is available in Pennsylvania, and that being the use of a consent decree, which can occur after the filing of a petition, but prior to an adjudication of delinquency. The Juvenile Court Judges Commission Delinquency Bench Book strongly supports the use of diversion and suggests that every juvenile court should have available a continuum of diversion programs. It further suggests that the juvenile court judge should take the lead in enlisting broad support for the development of a complete diversion continuum from system stakeholders and in educating the public regarding the purpose and value of diversion. As mentioned earlier, we've taken the opportunity to gather and analyze our Pennsylvania data regarding the major topic areas in today's presentation. On the screen, you can see what it is that we will be reviewing today about diversion. First, we'll look at who is coming into the front door of the juvenile justice system in our state by offenses committed, risk level, and prior juvenile justice involvement. Next, we're going to look at what is happening to these cases, particularly how many are being diverted and how many are proceeding to adjudication, with a special focus on how this varies across the state. Next slide, please. First, you can see that youth are coming into the front door of the juvenile justice system for relatively low-level offenses, and this chart indicates that the offenses that are represented by most frequently by youth coming into the juvenile court. 5 of the top 10 offenses on written allegations are non-felony offenses. And interestingly enough, the #1 offense on incoming referrals is non-payment of fines certified from a magisterial district justice. These certifications account for about 1 in 5 written allegations. What this means is that in Pennsylvania's juvenile justice system, summary offenses are not under the jurisdiction of the juvenile court. They're handled through a local magisterial district judge. And so normally after conviction, the sentence for a summary offense is fairly limited, is fines and costs. But in Pennsylvania, if a youth fails to pay those fines and costs, then it can come to the juvenile court, as mentioned, as a non-payment of fine referral. And that shows as the number one referral reason coming into our juvenile court. Next slide, please. You can see here that more than 70% of the written allegations are for non-felonies. And perhaps I should clarify, when I refer to a written allegation, for those of you that may not be aware, that's how a referral, an arrest, if you will, initiates in Pennsylvania's juvenile justice system. A written allegation is submitted either to the district attorney or to the juvenile probation officer, which starts the proceedings. And as you can see by this slide, more than 70% of the written allegations are for non-felonies. Okay, next slide, please. The next data show that more than half of the youth coming into the front door of the juvenile justice system are assessed as low risk to reoffend on the youth level of service risk needs assessment. Less than 10% are assessed as high or very high risk. The YLS, as we refer to it, is used consistently throughout the state in all of the 67 counties, and it is one of the most validated risk need assessment instruments that has been developed. And so it is used in many, for all of our cases, in order to assist in a number of different ways. But one of the measurements is whether or not the juvenile rates as being low risk, moderate risk, high, or very high risk. You'll notice that we've combined the risk levels of high and very high risk into one here. We've done this because a very small number of youth historically assessed as very high risk to recidivate. In 2019, there were only 33 youth statewide who were assessed as a very high risk in Pennsylvania. Next slide, please. Finally, the data show that more than half of the youth with written allegations in 2019 had no previous involvement with the juvenile justice system. In other words, a majority of youth with referrals were first-time offenders. In a few minutes, we're going to take a close look at what is happening with these youth who are coming into the front door of the juvenile justice system for the very first time. It's important to look at what is happening to this population of youth because they are coming in with a clean slate, if you will. They have no prior juvenile justice experience, have not had any prior dispositions offered that they may have failed on. So it is a good opportunity to examine how differently similarly situated youth are being treated across the state. So in short, we collectively see that most youth who are entering the juvenile justice system in the state are not committing serious types of offenses. They're generally scoring as low risk to reoffend on the YLS and generally do not have extensive juvenile justice involvement. So let's talk about what's happening to these youth once they're in the juvenile justice system. Next slide, please. This slide shows, first, among all written allegations, about half result in either a pre-petition diversion or a consent decree. And as you can see, across, from left to right are versions of dispositions: dismissed, withdrawn, pre-petition diversion, consent decree, probation, placement. As you go from left to right, the disposition is considered to be more serious and a deeper penetration of the system. So as you can see, about half result in either pre-petition diversion or a consent decree, which involves a petition, but does not ultimately involve an adjudication of delinquency. However, the utilization of diversion really varies across the state. Next slide, please. If you recall from a few slides ago, about 60% of the youth with written allegations in 2019 had never been involved in the juvenile justice system. Here we see that about 40% are diverted pre-petition and 68% are diverted from adjudication by some other means. However, when we look at these figures at the county level, we again see variation across the state in what is happening to these youth involved with the juvenile justice system for the first time. Next slide. So here you can see is an illustration of that on this map. In those counties that are shaded in the lightest blue, less than 25% of allegations result in diversion from adjudication, whereas in the county shaded in the darkest blue, more than 75% of allegations result in some form of diversion. Next, let's focus on just those first-time offenders and see what's happening with their numbers. Next slide, please. In some counties, nearly all of these youth are being diverted from adjudication, while in other counties, less than 25% are being diverted. Finally, let's focus on those youth assessed as low risk to reoffend. Next slide. And once again, we can see that there is a large variation across the state in what happens to youth who are assessed as low risk to reoffend, depending on where the youth lives. In some counties, less than half of the low risk youth are diverted from adjudication, but in others, more than 75% are. And so what we really see from these few slides is that while diversion is being widely utilized across the state, after controlling for risk level and prior juvenile justice experience, the data indicates that the likelihood that a youth receives pre-petition diversion or diversion from adjudication is largely dependent upon where the youth lives. Next slide, please. Is that slide 13? Okay, so you can see on this slide that nearly 80% of the youth are diverted from adjudication successfully complete their disposition without committing a new offense. So there's a huge success rate here in Pennsylvania among youth who received pre-petition diversion. In 2019, nearly 80% of the youth who were diverted from adjudication successfully completed it without escalating to a more serious disposition. So diversion, when used correctly, seems to be appropriate and effective in how it is utilized. Next slide, please. Our next topic has to do with an issue of interest to many of us that is outside of our juvenile justice system initially, but can have some significant impact eventually, and that is the impositions of fines and costs on juveniles following convictions on summary offenses. As we know, the Juvenile Act excludes summary offenses from the definition of delinquent act, and they are generally only processed if they are a lesser included offense with an allegation of delinquency. Nevertheless, if a child fails to pay the financial obligations of a summary conviction, the MDJ can certify to the juvenile court the failure to comply, at which time the youth is subject to juvenile court intervention. There's been ongoing discussion as to the utility of these failure to comply certifications. Critics point to the fact that these referrals constitute large proportions of youth from lower socioeconomic status families, which in turn may further increase racial and ethnic disparities. The question has been posed, should kids be subject to juvenile proceedings based mainly on the fact that they are too poor to pay fines and costs? So what does the data show us about these types of cases? Our overview of data in this section, we're going to be looking at how frequently the youth are being referred to the system for non-payment of fines and how that varies by county, and the dispositional outcomes of youth referred to the juvenile justice system for this type of offense. Next slide, please. First, as a reminder, in the last section, we saw that certifications for non-payment of fines makes up the largest share of incoming offenses on written allegations. Across the state, nearly 1 in 5 referrals are for these certifications from magisterial district justices. Next slide. For example, in 10 counties, more than 30% of all incoming referrals are for these types of cases. In 15 counties, however, no youth at all are being certified to the juvenile justice system for non-payment of fines. This again illustrates how similarly situated youth can be treated very differently depending on where it is that they live in the state. Next slide. Finally, we see that most youth who are certified to the juvenile justice system for non-payment of fines receive diversion from adjudication. One of the task force recommendations, although not fully endorsed by the membership, is to eliminate the ability to certify to the juvenile court failure to comply cases. A concern with this recommendation is that magisterial district judges under these circumstances would have little, if any, recourse in cases where fines in court and costs are not paid. The answer, it would seem, would be to develop creative alternatives for MDJs to utilize under these circumstances. Next slide, please. Much discussion has been ongoing regarding financial obligations as part of a juvenile court imposed obligation. The Juvenile Act provides that dispositions may include, quote, ordering payment by the child of a reasonable amounts of money as fines, costs, fees, or restitution as deemed appropriate as a plan of rehabilitation considering the nature of the acts committed and the earning capacity of the child. The Act allows for similar financial obligations to be imposed as part of a consent decree, as well as when utilizing an informal adjustment. Further, the Act requires that a juvenile not be released from jurisdiction of the court until the financial obligations are satisfied, and upon reaching the age of 21, the filing of a judgment against any unpaid restitution. Restitution is one of the court's most basic tools for holding juvenile offenders accountable and for providing a level of restorative practice towards victims. In this portion of the session, we're going to be looking at how frequently youth are assessed financial obligations, how this varies by county, how much youth are assessed in financial obligations, and how frequently judgments are filed against youth. Next slide. First, we can see that about 70% of youth who are assessed a fine, fee, or court cost. Next, let's look at how that varies across the state. We can see here that in most counties, more than 75% of the cases are assessed a fine, a fee, or a court cost. So among those youth who are assessed a fine, fee, or court cost, how many are able to fill that obligation? Next slide. Statewide, we see that approximately 90% of youth pay it in full by the time of case closure. Unfortunately, we do not have good data on how much is assessed by the juvenile justice system, but we do know how much is eventually collected. The average amount collected per youth is $112, while the median amount collected is $80. Next slide, please. Approximately 1 in 5 youth also have a restitution obligation. If you recall from a few slides ago, about 70% of youth have a fine or fee for a court cost obligation. So the most frequently occurring financial obligation are not restitution obligations, but rather fines, fees, and court costs. In addition, the average amount of restitution assessed per youth with cases closed was $1,094 in 2019, while the median amount assessed was $377. Next slide. Similar to fines, fees, and costs, about 90% of the youth pay their restitution obligations in full by the time of case closing. Next slide, please. Considerable discussion by the task force centered around appropriately responding to youth based on their measured risk levels. As you may know, the use of a validated risk needs assessment tool, currently the YLS here in Pennsylvania, is a requirement for participation in the Juvenile Court Judges Commission Grant and Aid Program. This is in large part due to the considerable research around how important it is to appropriately respond to youth based not only on their overall risk level, but also the degree to which they demonstrate criminogenic needs as measured by the YLS. The YLS risk assessment and attention to the principles of risk, need, and responsivity provide the foundation of our work to implement the juvenile justice system enhancement strategy mentioned earlier. A key provision, one that is most basic to research, is that low-risk youth should not be over-serviced and in most cases are appropriately for diversion from formal court processing. Mixing low-risk youth with moderate and high-risk youth has been proven to increase recidivism rates for the low-risk youth. We also know that the most effective way to reduce recidivism is by targeting interventions to the identified criminogenic risk areas identified by the YLS, and that court orders and case plans should reflect these facts. So understanding the importance of this tool in the state, we're going to look at the following. What are the risk levels and criminogenic needs of youth coming in the front door? We're going to also look at the dispositional outcomes of youth assessed as low risk. And finally, we're going to look at the recidivism rates by risk level of the youth. Next slide, please. We saw this slide earlier today, but to quickly review, the data show that more than half of the youth coming into the front door of the juvenile justice system are assessed as low risk to reoffend based on the YLS. Next slide, please. Statewide, 70% of these youth are diverted from adjudication. However, remember that percentage varies greatly based on the county in which the youth lives. Next slide. Finally, the data shown on your screen were part of the most recent recidivism study published by the Juvenile Court Judges Commission. Each youth in the study was identified by their last risk assessment and subsequently tracked for 2 years post-case closure. The results indicate that youth identified by the YLS as high or very high risk were most likely to recidivate within 2 years of case closing. On the other hand, youth identified as low risk were least likely to recidivate within 2 years. This data therefore serves as validation of the YLS risk needs assessment tool. Next slide, please. A great deal of attention by the task force was focused on the use of out-of-home placement as disposition in delinquency cases. We're all aware that this disposition should be reserved as a last and most restrictive alternative. And here in Pennsylvania, we have reduced the use of placement as a disposition by over 70% over the past 10 plus years without jeopardizing public safety. Our Juvenile Act dictates the strongest possible preference for non-custodial dispositions over custodial ones, and the delinquency bench book echoes this consideration. In this section, we're going to spend some time diving into the residential placement as a whole. Most specifically, we will be looking at how frequently youth are placed out of home as a disposition, how frequently youth are moving between facilities, how long youth are remaining outside of home, and at what point in the case youth are most likely to be placed. Next slide, please. First, between 2010 and 2019, placement dispositions decreased by 60%, which is represented by the orange line in the chart on your screen. In the same time period, written allegations decreased 43%. So placement dispositions have decreased at a faster pace. So what does the risk levels of youth within placement dispositions? About 2/3 of youth with placement dispositions were either low risk or moderate risk, and about 35% were identified as high or very high risk. And upon further digging into the percentage of youth that were identified as low risk, the data indicated that many of these youth were sex offenders, but otherwise their profiles largely mirrored the profiles of youth who were identified as moderate or high risk. So once a youth is in placement, what does their experience look like? Next slide. First, youth with placement dispositions average about 2 residential placements over the course of their case, though 25% youth with a placement disposition spend time in 3 or more residential placements. Next slide. Cumulatively, youth with placement dispositions spend a median of 9 months in residential placement. Next slide. Among all youth with placement dispositions, half go to placement as their initial disposition and half go as a result of a dispositional review. We know that placement can either occur as an initial disposition for the offense or as a result of an ensuing dispositional review hearing, which often is initiated as a result of a technical violation of probation. Much attention is being focused on outcomes of technical violations of probation, and some recommendations have been floated that would eliminate placement as a response to these situations. Amid this has been a related discussion about the implementation of graduated response programs, which are broadly viewed as providing a safeguard from the accelerated use of placement in response to technical violations. Next slide, please. One of the more alarming findings throughout the task force activities was the ongoing matter of racial and ethnic disparities. At what decision points are racial and ethnic disparities most prevalent? Next slide, please. First, relative to written allegations, disparities are greatest at the most serious points of the system: removal from home and transfer to criminal court proceedings. Now, I know there's a lot of information on the screen right now, so I want to make a moment to walk through all of this. All the data represented here are based on the youth's initial disposition. The very first bar in the chart shows us the distribution of Pennsylvania's youth population. We see that Black youth, shown in the dark blue box in the bar, account for about 14% of the state's youth population. White youth, shown in the gray box, account for about 70% of the Pennsylvania youth population. In the next set of bars, we can see the distribution of youth coming into the juvenile justice system via a written allegation. About 37% of the allegations are for Black youth, while 45% of allegations are for white youth. Now, given that distribution of who is coming in the front door of the system, we would expect that if disparities did not exist, Black youth, for example, would account for about 37% of each decision point. In other words, if disparities did not exist, we expect that Black youth would account for 37% of pre-petition diversion, 37% of consent decrees, and so on. However, we can see that this is simply not the case. I would like to draw your attention to pre-adjudication detention, placement, and transfer to criminal court bars. This is where we see the largest disparities in the state. And again, those decision points happen to be the most serious points of the system: removal from home and adult prosecution. And when we look at this data for Black males only, the findings are even more stark. Next step, next. Black non-Hispanic males make up 7% of the youth population, 27% of the written allegations, and 47% of all placement dispositions. Next slide, please. I mentioned previously that well-documented collateral consequences of an adjudication of delinquency here in Pennsylvania occurs and exists. Our Criminal History Record Information Act provides for the expungement of juvenile records with criteria depending on the specific disposition utilized for each case. And expungement is generally supported as a vehicle by which these consequences can be minimized. In this section, we're going to first preview how expungement policies and practices vary across the state. In 2018, the Juvenile Court Judges Commission sent out a survey to juvenile probation departments to gather information on how expungements are processed in each jurisdiction. Next, we're going to review how frequently expungement eligible cases are actually expunged and how this varies across the state. Using a population of dispositions that were eligible for expungement beginning in 2019, we will look at how frequently these dispositions were actually expunged and how this varies across the state. Next slide. There is wide variation in costs associated with expungement. Some counties, there's no fee at all. Others, there is a fee. And among those counties that charge a fee, its fees range from $25 to $132.50. Next slide. The data indicate that most eligible records are not being expunged. First, according to a Juvenile Court Procedural Rule 170, any petitions dismissed can be immediately expunged, but according to the data, only about 24% of the instances where this occurs was the record expunged. Next, according to the rule, any allegations withdrawn can be immediately expunged, but according to the data, this is occurring in only 33% of the instances. In instances of informal adjustment and consent decree, Rule 170 states that the disposition can be expunged after 6 months from the discharge from the disposition. However, only 26% of informal adjustment dispositions and 32% of eligible consent decrees from 2019 have been expunged. And finally, in scenarios where a youth has been adjudicated, Rule 170 states that the disposition can be expunged after 5 years from the discharge from the disposition if the youth does not have any charges pending. However, only about 4% of these eligible cases are actually expunged. And so how does this vary by county? As you might expect, given what we just saw and how practice varies across the state, there's a large variation in the proportion of eligible dispositions that are actually expunged. Even still, in most counties, less than 25% of the eligible are done. Much discussion has circulated about these issues related to expungement and the fact that practices are highly consistent. Some consideration is being given to having standardized expungement process, which may even become mandatory and or automatic. The issues that we just went through are far from inclusive of all of the recommendations and findings of the task force, but it certainly represents some of the most significant ones. Next slide, please. As I mentioned previously, in many ways, the work is just now starting. There are numerous pieces of legislation to be introduced in the not too distant future in an attempt to address some of the issues raised by the task force. In addition, the Department of Human Service regulations governing the operation of licensed residential facilities are in the process of being amended, and the Pennsylvania Department of Education is considering how to provide additional oversight to the provision of education in residential facilities. The Juvenile Court Judges Commission staff, in conjunction with Pennsylvania Council of Chief Juvenile Probation Officers and other stakeholders, are working on standards for the implementation of graduated response programs, as well as developing strategies for enhanced data analysis and county-specific technical assistance. And the Juvenile Court Procedural Rules Committee is considering how to respond as well. We're hopeful that some of the savings realized from the reduction of expenditures for out-of-home placement can be reinvested in our system directly, as well as an increased prevention services to boot. These savings have been significant over more than a decade of efforts on the part of juvenile justice to reduce the use of out-of-home placement. It is noteworthy that in fiscal year 1920, that being 2019-2020, expenditures for out-of-home placements were over $164.5 million less than what was expended in fiscal year 08-09. Now keep in mind that this is a one-year difference, not for that entire time span. So by far, however, the most significant pending activities coming out of the task force will be focused on legislative initiatives now being considered. Next slide, please. Since the final report was released, staff of the Pew Charitable Trust, who provided staff support and direction throughout the entire process, have proposed legislation that would address virtually every one of the 35 recommendations that could be addressed through legislation. As such, proposals have been distributed to 5 different Senate committees for consideration. They include the State Government Committee, Health and Human Services Committee, Aging and Youth, Education, and the Judiciary. It's my understanding that the introduction of task force related bills will be occurring in the very near future. So let's take a quick look at some of the proposals in a general sense. Next slide, please. Within the State Government Committee, the recommendations include the creation of racial impact statements for juvenile justice related legislative amendments, the Pennsylvania Commission on Crime and Delinquency receiving allocation of juvenile justice savings to fund non-residential evidence-based practices, the expansion of membership of the Juvenile Justice and Delinquency Prevention Committee of PCCD, and the issuance of data reports annually, and the establishment of statewide Youth and Family Advisory Board as part of PCCD to emphasize the use of family engagement. Next slide, please. For the Health and Human Services Committee, recommendations include that the State Inspector General's Office be empowered to provide oversight of state-operated juvenile residential facilities, which are operated, by the way, by the Department of Human Services, who otherwise oversees and licenses other residential facilities. It also recommends amending the the Human Service Code to include juvenile justice and child welfare goals. This is deemed being supportive of a stronger funding source for services. It also recommends the tracking of data on the use of out-of-home services, including denied admissions to residential facilities and individuals who are ejected from residential facility placement. And finally, recommendations around the prohibition of certain restrictive procedures, including restraints, seclusion, and strip searches in residential facilities. Next slide. The Aging and Youth Committee recommendation would create the Office of the Child Advocate within the Attorney General's office here in the state. Next slide. The Education Committee includes recommendations to amend the definition of weapon in school code for the purpose of automatic expulsion proceedings. This is significant in Pennsylvania. It would also recommend limitations of arrest and police referrals while on school grounds in an effort to eliminate or at least make smaller the school, as they call it, the school to prison pipeline. It would recommend expanded PDE oversight of educational programs in residential facilities. And also it would establish school stability requirements for youth who are removed from home and otherwise return to their educational setting. As might be expected, the Judiciary Committee has the most recommendations, which include Department of Human Service reimbursement for stronger reimbursement for diversion programs to keep kids out of the juvenile justice system, state funding for the provision of juvenile indigent defense. Pennsylvania, I believe, is the only state that does not provide support funding for indigent defense. It recommends the reinvestment mandates for savings from reduced out-of-home care to be used for various reasons. That's the money that I spoke about a little earlier. Recommendations for statute that require automatic expungement proceedings for eligible youth, the removal of failure to comply as a delinquent act, the elimination of direct file provisions of Act 33, 1995. That's a group of charges under certain circumstances by age and the type of charge that automatically places a youth in the adult criminal process as opposed to the juvenile process. And also a recommendation to raise the age of delinquency from 10, which is the current lower age, to age 13. Next slide. Additional recommendations: mandatory pre-petition diversion for the first 2 referrals to a juvenile court for all misdemeanors and nonviolent felonies. The elimination of most costs, fines, and fees as part of a disposition, reducing the ability to use pre-adjudication detention, which is secure holding, limited extension of a consent decree, limited ability for the court to place a youth in a residential facility at disposition, limited ability for the court to place youth as a result of technical violations of probation, out-of-home placements to be limited to 6 months maximum in most cases, except for murder or a sexual offense. Next slide, please. And finally, recommendations: the transfer to criminal proceedings must be 16 years of age or older within the juvenile proceedings. Next slide. Needless to say, a number of the recommendations that are being included in the report were not unanimously supported by the members of the task force, and to a greater degree, disagreements are significant about some of the specifics of the recommendations being made. It will certainly be interesting to see what of the recommendations end up being introduced and how the legislative discourse goes on after their introduction. It is certainly my opinion that many, if not most of the recommendations coming out of the task force, if implemented, will serve to strengthen our juvenile justice system. On the other hand, frankly, I think there are other recommendations that I believe would be bad public policy if enacted. Only time will tell how this all pays out. At this point, I'd stop, see if there are any questions or comments.
Yes, if there are any questions, we have time for maybe one or two quick questions if anyone has a question. And let me start, Rick, with what you've seen working with the task force. I understand there were a number of disagreements amongst the parties. Are there any of the legislative priorities that you think may make it through to actually become law here in Pennsylvania?
Yeah, I think there's a couple of, we call them low-hanging fruit recommendations. Some of them have to do with amendments to the Human Services Code that would provide for specific definitions of the goals of both for dependency and delinquency, which would assist in, because that's the funding code, and it would be much easier to assign funding to activities that meet the needs that are established. We're also looking at taking a close look at the expungement, the way it currently is, and really pushing to see that we not have automatic expungement in terms of every case would be expunged, but we would have automatic expungement proceedings initiated whenever a case is eligible for expungement, because now, as we saw by the slides, there's so many cases where expungement is available and it's not occurring. And collateral consequences in Pennsylvania are very significant. So those are a couple of the big ones. I have to jump in. This maybe doesn't answer your question directly, but one of the recommendations is very significant, and it's a bit controversial. And that recommendation is that we do away with what's called direct filing. Act 33 of 1995 allowed for the expansion of the types of offenses under certain circumstances that automatically place a child into the adult criminal proceedings, and that ultimately they possibly can transfer back to juvenile proceedings, but it's timely and it's a rather significant process to go through. What we saw as we were going through and talking with a number of individuals that have been involved with the juvenile justice system, that the experiences of individuals, of youth who have been direct filed, going into county prisons, spending time in adult facilities, their discussion is very compelling. And I believe our argument is that so many of those cases, the data shows that so many of those cases end up either being transferred back to juvenile court or being dismissed at the time of preliminary hearings. And so there's not a whole heck of a lot happening except for those ones that continue, and they're getting some fairly significant both local and state incarcerations. The Juvenile Act in Pennsylvania has a provision that allows for the transfer to criminal proceedings for cases that in effect are not deemed to be amenable to treatment. And I do believe that piece of the Juvenile Act would take care of kids who, unfortunately, there are some who simply are not amenable to treatment as a juvenile. And that would be a process where a juvenile court judge would have the ability to make that assessment with the knowledge of what's available and what interventions can occur with juveniles in terms of making that decision. That's there. It's part of the Juvenile Act. That recommendation was supported by far the vast majority of the task force participants, but unfortunately, it is not being supported by the district attorneys across the state. And unfortunately, I believe that will be the end of that recommendation.
Well, thank you very much for that thorough answer. I view it the same way that you do, because we see a lot of those direct files winding up in prison jails, I should say, that more trauma is inflicted on those kids needlessly. So, but it doesn't sound like that's going to get through. So, thank you very much. Join me in thanking. Oh, I'm sorry. No, there's not a question. There was just a comment. Thank you for your comment. Join me in thanking Rick Steele for his presentation, and I will now turn it back over to Dean Hussey.
Thank you all for joining us. I'd like to thank Mr. Steele and Judge Morris for putting this great program together, and to Adrian McClendon and Rob Teplis for all they've done with law and government. So thank you for joining us. In the chat, there is the link to the CLE form. If you click on that link and fill out the information, we will email you the certificate of attendance for today's program. Thank you all for joining us. Have a great evening.
Thank you all.